Commissioners, Mr. Campbell is here today after failing to appear before this court on March 22nd, 2023. In the first case, bond is currently set at $1,977. This is the second bench warrant. In the second case, bond is currently $2,392, and this is the third bench warrant. I do not have any employment information, but last payment made on these accounts was on May 22nd of 2023, and that was the income withholding, which has been in effect since January of 2023. Front of the court recommends that reasonable bonds be set in each of these matters, and they be scheduled for hearing on June 21st, 2023 at 8:45 a.m. before this court.
Mr. Campbell, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 21st, 2023 at 8:45 a.m. Are you still employed, sir?
Yeah, excuse me. Yes, I've been employed since I got out. I got out December. I just gave these guys 2.5 months down here. When I got out, I got employed. I talked to my enforcer in February, and she told me that she would quote unquote be in touch. My address has not changed. I even called down there and made sure that my address and my number was on file. I have not missed a payment since I've been out. I've been employed. I'm still employed. And I was aware of none of this information. I didn't know I had a court date. I didn't know that I was supposed to be here. I didn't know I had any warrants. I didn't know any of this was going on. Otherwise, I would have came and took care of this. As you can see on my records, I haven't missed a child support court date almost ever. So I don't understand the situation. But yes, I was totally not informed of any of this.
Okay. Where are you employed at, sir?
I'm employed at I Stanley, and it's through a temporary service called Ethics Management. I've been there almost 2 months.
Okay. Well, the court notes in this matter that you have paid up through May 22nd, 2023, that you've been paying through income withholding. The court is taking that into consideration. What I'm going to do, I'm actually going to set your bond in the amount of $0, so you're able to get out today's date. You understand that, sir?
Yes.
Okay. So just make sure that you keep paying and that you can show up on the June 21st date, or contact your caseworker. You can contact your caseworker before that and see if something can't be worked out with them. Okay.
Okay. So now, all of this is for the FOCs and the failure to appear. All of this is like my bond period. I know it's like $3,000 or $4,000, but I had the failure to appear charges too. So is all of this one?
I guess I don't understand the question, but yes, it's this matter will all be taken care of on the 21st.
So now I have no, I don't have to like pay cash to bond out now?
Correct.
Okay, so I'll be released like immediately?
Well, as soon as we can get the order done, it might take an hour or so before we get the orders, but as soon as the orders are processed and signed, then you'll be able to get out.
Okay. So I won't have to go to any other, like they told me I had a court date at 1:30.
I don't know. I don't know what you have at 1:30. I have no idea. All I know is today's date or June 21st. If you have a notice to appear for another court date, you're going to have to do that.
Okay, because I had 3 failure to appears and then the 3 FOC cases. So everything is FOC. So the failure to appear, I'm talking to you guys about that right now, right?
Right. For the 2 cases, the 2018 and the 2012 case. If you have any other matters, you need to appear at the stated time, or you'll have another bench warrant out for you.
Okay. I understand now.
Okay, thank you. You're free to go, sir.
2817DS. Mr. House is here today after failing to appear before this court on June 7th, 2023. Bond is currently set at $2,211. This is the third bench warrant. I'm unaware of any employment information. There was a $903 payment made on June 2nd of 2023. Prior to that, the last payment was in June of 2021. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 21st, 2023 at 8:00 a.m. before this court.
Mr. House, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 21st, 2023 at 8:00 a.m. Are you able to post a bond, sir?
Yes, sir. And I had noticed that they had my mother's address down for my address. That makes a lot of sense why I have not been getting the court papers. I don't live with my mother anymore.
Okay, when you get out, you're gonna have to go to the front of the court and fill out a form for change of address, or they'll just keep sending it to the last known address that you have.
Okay, makes sense. I appreciate it.
What are you able to post as far as a bond, sir?
I would have to call my mother to have her come down. So
Did you make the payment of like $903 and something on the June 2nd date?
yeah, I did.
Okay. Well, in view of that, I mean, the bond amount is pretty substantial, but in view of the payment that you made, I'm going to reduce your bond to the sum of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
Mr. Watkins is here today after
Okay.
failing to
Thank you,
appear
sir. You
before
have a good
Referee
day.
Snyder on May 23rd, 2023. Bond is currently set at $7,328. This is the 7th bench warrant. He reports that he is self-employed. Last payment made on this account was in May of 2020. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 21st, 2023 at 8:45 a.m. before this court.
Okay, thank you. Mr. Watkins, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 21st, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
The day I got out of jail, I broke my right leg, and I was in a cast for 6 months. And just last week, I'm in a wheelchair right now with a broken left leg and broken ankle, and I have a broken nose and broken teeth. I got ran over. So I've been medically down. I haven't been able to work. I have medical proof of all that. I've gotten anything in the mail from anybody. I don't know where you guys are sending my mail to.
Well, we'll send it to your last known address. So if you have moved and you haven't changed that, then it's going to the last address we had.
They took my house from me when I went to jail this time, and they just boarded it all up with no court order, no anything, and allowed people to go in and take over my home with no explanation. And I'm not sure what's going on with that. I'm trying to figure all that out. But I haven't been able to make a phone call since I got here on Friday. I've been denied the ability to make a phone call. They haven't let me out of my cell. And so I haven't been able to figure anything out since I've been here.
Okay. Well, what I'm going to do is I am going to reduce your bond substantially in hopes that you could be released pending that particular hearing. What I'm going to do is I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released, and you'll need to go to the front of the court and change your address so that you're able to get your mail.
Okay.
Ms. Rue
Okay.
is here
Thank
today
you.
after failing to appear before Referee Nets on October 27th, 2021. Bond is currently set at $500. This is the 2nd bench warrant. She reports that she is employed at TRMI. Last payment made on this account was in October of 2021. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 21st, 2023 at 8:00 a.m. before this court.
Ms. Rowe, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 21st, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
No, I actually start working tomorrow. I have orientation, so it's like just starting thing. I've been going through a lot of stuff last couple years and stuff, and I didn't get I moved, so I didn't get the notice of court papers and stuff. So
yeah, you have to keep your address updated, or they just send it to the last known address.
Right.
What I'm going to do is I am going to reduce your bond and hope that you could be released. Although I do note it's your 2nd bench warrant, and I note that you haven't paid in a year and a half at least. So what I'm going to do is set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
yeah, so if I don't come up with $200, I can't get out until the court date.
That's correct. That you'll be there until the 21st.
Dude. So I'm not, man, dude, I have no way to come up with this money. I start tomorrow. Like, oh my God.
Thank you, ma'am.
Mr.
That concludes
Gonzalez
this
is
matter.
here today after failing to appear before Referee Snyder on October 4th, 2022. Bond is currently set at $9,941. This is the 3rd bench warrant. He reports that he is employed at Challenge Last payment made on this account was on June 7th of 2023. That was through income withholding, which has been in effect since May 24th of 2023. The Calhoun County Sheriff's Department is requesting transportation cost reimbursement in the amount of $258.52. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 21st, 2023 at 8:00 a.m. before this court.
Mr. Gonzalez, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 21st, 2023 at 8:00 a.m. You will get notice of that in writing. Are you still employed at Challenge?
Hopefully, yes.
Okay.
I was supposed to work over the weekend and I kind of missed
Okay.
Friday.
Okay. Well, what the court's going to do is you have been paying through income withholding, so the court's taking that into consideration. Do you have any money you could post as a bond, sir?
A little bit, not very much.
Okay, and what's a little bit?
I got maybe 500 on me right now.
Okay. Well, what I'll do is, court will, I'm going to take a little less than that. I will set your bonding amount of $400. Also order that you would reimburse the sheriff transportation costs of $258.52. You're able to post the bond, then you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. And again, we'll see you back on the.
Mr. Williams is here today after failing to appear before FRA Delmont on September 23rd, 2021. Bond is currently set at $3,685. This is the fifth bench warrant. Your report said he is employed at Thurmond Commercial Cleaner. Last payment made on this account was on May 11th of 2023, and that was through income withholding through the unemployment agency. The Calhoun County Sheriff's Department is requesting transportation cost reimbursement in the amount of $133.76. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 21st, 2023 at 8:45 a.m. before this court.
Thank you. Mr. Williams, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 21st, 2023 at 8:45 a.m. You will get notice of that in writing. Are you still working at Thurmond?
Yes, sir.
And
Yes, sir.
Are you able to post a bond, sir?
Some, yes, it depends on how much it is, sir.
Well, how much do you have that you'd be able to post as a bond?
Including the transportation,
Yeah, how much?
maybe 300, maybe.
Okay. Well, what the court's going to do is, court, I am going to reduce your bond substantially because you have paid up through the May 11th date. I don't know what's happened since then. If you're still employed, I can't understand why you haven't paid after that date. Do you know?
Well, no, I don't like I don't always have employment, and then I stay in Kalamazoo, so it's like it's hard for me to, get around and stuff on the bus. So and then I don't know my address. I have a solid address now, but yeah, I don't know what happened before though.
Okay, what you're going to have to do is go to the front of the court's office and provide them with your new address so that you get your paperwork, or otherwise the same thing will happen again. You understand?
Yes, sir. Yes, sir.
Okay. Well, what I'm going to do is I am going to order that you reimburse the sheriff transportation costs of $133.76. I'll set your bond in the amount of $300. You're able to post that, you'd be able to be released. Do you have any questions?
So how much would it be altogether with the
bond is $300, so that's what you need to pay to get out, and then you'll have to also pay the sheriff at some point the $133.78. 76 cents. I'm sorry.
Okay, so it's not all together.
Correct.
Okay, I got you. Thank you.
Okay, thank you.
Yes,
Court will note the appearance of Ms. Wilson on behalf of the
Thank you.
plaintiff. This matter is before the court on the plaintiff's motion to reinstate the case. Ms. Wilson, as I go through your motion, I note the motion says, and I quote, plaintiff believes it has good cause to request the reinstatement of the case. However, there's never any good cause stated in the motion. I wonder, are you keeping it a secret or what?
Well, Your Honor, we apologize if that was left out. The good cause was in fact that this was a case that we received a scheduling order prior to service. And our experience has been, and we haven't had a lot of experience with this court, so I apologize that we didn't catch this, that if the defendant has not been served, then the scheduling order and or a pretrial cannot proceed because the defendant doesn't even know there's a case that exists. So other courts that we've been familiar with, such as the Oakland County Circuit Court, they automatically just adjourn until they see a service, or they actually we file for a motion for a second summons, or the summons fails for failure process.
Well, Ms. Wilson, what we had set up is we had set up by separate notice. We set up a status conference, and the purpose for the status conference so we can find out the status of the case. Well, we can't do that when you don't appear.
Okay. And again, my apologies. We did not pick up on that. And all I can do is apologize. It was my misreading. I certainly am not going to not take blame for what happened.
Sure.
But on the other hand, I felt that it was most efficient for all parties concerned, defendant, the court, myself, to reinstate the case rather than having it dismissed, refiling. The same thing, at this point in time, the defendant has been served. He doesn't know that there's a case involved against him and has the opportunity to respond. So to dismiss at this point or allow the dismissal to stand would only mean that we'd have to start the process over, which although I've made a mistake and I do apologize, it's one that I haven't made before, that doesn't matter. I am asking the court to kindly grant our motion to reinstate because as I mentioned, I believe it's beneficial and efficient for all parties, including the court concerned.
Okay, so the defendants have now been served?
Yes, Your Honor, and I believe the service has been filed with the court. That's, my assistant does that, but she did mention, I see that there was a letter that went out June 2nd, 6th, 2023, with the notice of personal service to Platinum Interiors of Southwest. And that service was affected by Justin Dove, perhaps. I can't really read his signature.
Okay.
So yes, the defendant has been served and notice of that service has been directed to the court on June 6th.
Okay. Well, in this particular matter, the court notes, obviously the court has discretion in the matter. I would state my initial inclination in this matter was not to reinstate, especially because I note in the motion, it says that the plaintiff was still in the process of serving the defendants. As a result, again, that was my inclination, but in view of the fact that the defendants have been served, the court does believe it's probably in the interest of judicial economy to reinstate the case. So I will reinstate the case, and you can file an order of reinstatement under the 7-day notice of entry. I will caution you in the future, if we send you notice of a hearing, you better show up at that hearing because the court will not reinstate a case or do anything of that nature in the future. So.
Today is Monday, June 12th, 2023 at 10:02 a.m.
Court will note the appearance of Ms. Duncan White on behalf of the plaintiff, Ms. Corrigan on behalf of the defendant. This matter is before the court on the plaintiff's motion to abate support arrearage. An answer has been filed in this matter, and Ms. Duncan White, I note in the answer, Ms. Corrigan has stated, she said, well, when the order was entered in this matter, that the plaintiff did not file an objection to the support order. So why should the court consider it now?
There was no signed order that was put in. That's even what came to us from the friend of the court, that the FOC received the order from the court. They had no choice to enter it as written, but it reflects that it creates an arrearage immediately going back a year when Your Honor only signed this order 2 months ago. And so, Mr.
Okay, my question of you didn't have anything to do with when it was in. It said that, again, when the order was submitted, there was no objection filed to the order at the time it was submitted.
Your Honor, Miss Buford was denying access of the child to Mr. Buford on a regular basis and continues to do it here today.
Are you going to answer my question about the support? I don't care if she was denying or whatever. That's not my question. My question was when the order was submitted and he had an opportunity to object within his 21 days, he did not object.
We objected, and we were told that the friend of the court could not accept it. I'm trying to find the verbiage. It was returned to us because the friend of the court could not find an order for us to be objecting to. It says, we've received an objection to a child support review. Please be advised this is not a friend of the court order issued due to a support review. Therefore, the objection should not have been filed with us. That is why we filed with you.
Okay, go. Duncan White, you can go ahead with your motion.
Thank you, Your Honor. As stated just momentarily, when this order was signed, it was signed in May of 23, but it backdated to March of 2022. And the friend of the court's policy required that those dates be honored, even though Your Honor just signed it. And they, wrote this letter to me explaining this policy as to why an arrearage was created in the first place. Mr. Buford has done everything he could to see his child. He offered to see her on a regular basis during the 10 months that the process was going on. Ms. Buford denied him that access and still denies him that access to this day, even after the divorce is final.
Ms. Duncan White, this issue goes to the abatement of support. I don't care about him trying to see the child, her not denying. That's not the issue. The issue is your motion to abate support. So please don't keep going into the issues of parenting time.
Thank you, Your Honor. We stand on the policy of the friend of the court that this was created, this arrearage was created not as of Mr. Buford's fault, but as the policies of the court, and we ask that it be abated.
Okay, thank you. Ms. Corrigan?
I stand on my answer, Your Honor.
Okay. Well, in this particular matter, there were lengthy actions. There was a denial of paternity. As a result, we had to proceed under a revocation of paternity action. That delayed the uniform child support order in this matter. The plaintiff failed to provide some insurance premium information, and that delayed the issue somewhat as well. And the court would note during this entire time, the plaintiff did not pay any child support. And it is the practice of the court, as provided for by court rule, that if a order is entered at some point, that it goes back to the date that an investigation or a determination is again ordered as it relates to support. So the plaintiff in this case has not been prejudiced, other than the fact that he now has an arrearage. But if he would have paid at the time that order went into effect, he wouldn't have an arrearage at this point. So the court at this point does not see any basis for an abatement of a support arrearage. The court will deny the motion in this matter. Ms. Corrigan, you can submit an order denying the motion under 7-day notice of entry, and that will conclude this case at 10:08 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This case, the matter is before the court on the defendant's motion to set aside default. Mr. Butler Arnett, you have to establish good cause. What's the good cause for setting aside the default?
I'm unemployed, and I had up until recently, I've had the kids quite often, almost every other day, or that's every other weekend. And I am a single father. I can barely afford my rent. I don't have food assistance or anything, and it's hard to even feed the kids. And I'm sorry, I just woke up, but the kids are what's most important to me. They're the reason I try to do better. But the default amount of money is just, there's no way I'd be homeless if I had to pay that amount.
Okay. Anything else, sir?
No.
Okay. Ms. Ayers, anything on your behalf?
I am giving Mr. Arnett the benefit of the doubt due to his situation. He has had the kids more recently than he has in the past when I did file. He gets them, he had been getting them for a few days, for a couple hours a day, and then an overnight, usually during the weekend. So he has been getting them a little bit more, but he is jobless right now, and it is hard to feed them when he has them. So I do agree with him with the amount is a little high. So I'd be okay with like $100 or $120 a week versus the 180, I think it is. But,
Okay, thank you, ma'am.
mhm.
Mr. Magnuson.
Your Honor, I would just note that everything in this case was done procedurally appropriate. The summons issued on March 10th of 2023. Service was effectuated on March 15th. No responsive pleading was filed, and a default did enter on April 12th of 2023. We had the hearing in front of the referee. At that time, both parties appeared and the default judgment was entered. That being said, obviously, as the court knows, these orders are subject to modification, and I don't believe that there's a legal basis to set aside the default or the judgment, but a review or the friend of the court has no problem with a review of his situation and setting support based on his current reality.
Okay. Mr. Magnuson, how are we going to accomplish that? Is that you want to put that in an order, or do we want to have Mr. Butler Arnett file a motion for that?
I have no problem if it would ease the process in preparing some type of order to that effect at the front of the court, or that there'll be a review, however the court wants to handle that. I have no problem with that.
Okay. Well, in this particular case, the court notes that Mr. Butler Arnett did in his motion state that he did not answer because he was between jobs and wasn't sure of his income. Well, that doesn't rise to the level of good cause to set aside the order of the court. What I'm going to do, Mr. Butler Arnett, I'm going to deny your motion to set aside the default, but as based upon what the plaintiff had stated, Mr. Magnuson, we're going to include in that order that there would be a review of the support to take into account your current circumstances in this particular matter. So I guess, Mr. Magnuson, I'll ask that you would prepare the order, submit under 7 day. And then Mr. Butler Arnett, when you're contacted by the front of the court, make sure that you provide them with all of your income information, et cetera, so that they can prepare the appropriate review of the support, and that in fact, so the amount would get set properly. The court will go, and as you prepare that order, Mr. Magnuson, the court would make any modification effective the date of the motion in this particular, service of the motion, which will be approximately 3 days after the date of the motion.
Your Honor, I don't have any income. Okay. I don't have any income.
Well, the front of the court will do a review, and whether it may determine that it's appropriate to impute income. Just because you don't have income doesn't mean that it would be set at zero if in fact there's a basis to impute income to you. So that will be one of the issues that will be addressed at the time of the hearing on that review. Okay.
Yes, sir. And I, when I first got the court papers with the default amount, I did send in a response, but it was sent to the wrong place in the court system.
Okay. Well, the court's made my ruling. The order will reflect that, and then you'll have to pursue it through the front of the court process. I guess, Mr. Magnuson, I don't know that we need a investigation. We can simply send it back to the referee for a review and probably get it expedited and have heard a little bit faster.
I think that would be the easiest way to do it.
Yeah. Okay. We'll prepare that order, submit it to court. We'll end this matter at 10:36 a.m. You're free to go. Have a good day. Court will note the appearance of Mr. Nelson. The matter is before the court on the defendant's motion to set aside referee recommendation. Mr. Nelson, I note in reviewing the file, we didn't have a proof of service in this. Did you serve the plaintiff?
Yes, sir.
Okay. I note your basis for setting aside the recommendation was that you had to work, and therefore, again, you didn't appear at the hearing. The court has to establish whether there is good cause to set aside that recommendation. I'll tell you, the fact that you had to work is not good cause for not appearing and not setting it aside. You could have requested an adjournment. You could have done a number of other things to have that hearing heard at a different time, but didn't. So what is the good cause for setting aside the recommendation?
I don't think I'm kind of following on it. As far as what I'm paying.
It's your motion, sir. You're the one that's objecting.
My thing is, sir, now I've been maintaining the job for 5 years. I've lost 3 homes, 2 cars. I'm paying too much, so I can't even live myself. I can't even survive. My child support, I'm paying, they get more money than I get. I have to borrow my job, it has to help me even feed myself.
Okay. Sir, what I could do is the court, as I noted, you've not established good cause, but again, the initial thought was of the court is that I would simply deny the motion. You could file a motion for modification, but that probably wouldn't have proved to be real effective in accomplishing what we want ultimately. What I'm going to do is I'm going to send the matter back to the referee for additional hearing. What's going to happen, I will tell you at this point, you're going to have to appear at that hearing, because if it gets sent back to the referee and you don't appear again, the court's not going to give you another bite of the apple and say, okay, well, we'll give you a chance at a third hearing. Okay, you've got this chance, and you need to get in and present what your income is. So you'll have to have paycheck stubs to provide to the referee, et cetera, so that your support can be set at a correct amount. If you don't do it, then unfortunately, you're going to be stuck with that higher amount. You understand?
Yes.
Okay. So the court will refer the matter back to the referee for additional hearing on the issue of support. And at that time, you can appear at that hearing and present any and all evidence. That's testimony, other evidence, paycheck stubs, anything else that you have that would go to the issue of your income in this matter. Okay?
Okay.
Okay. Thank you. The court will end this matter at 10:45 a.m. You're free to go. Have a good day.
Well, would I get a notice of my court hearing?
Yes. Yep. Make sure that you do have your correct address on file with the front of the court. If you've moved or anything, you're going to have to fill out a form at the front of the court notifying them of any change of address. Good morning to both of you. Mr. Hathcock, as you have filed the petition requesting a PPO in this matter, the court did deny the ex parte request dated on May 8, 2023. Sir, tell the court why you believe that the court should enter a personal protective order.
You want me to go over everything?
I want you to go over whatever basis are that you believe you should get a personal protective order. This is the time to present that.
I just want her to be restrained from coming near me or my home.
Okay. And what is the basis for that?
That she continues to threaten and state that she has every right to and will continue to.
Okay. Well, you got to be specific. She threatens and continues to say she's going to do what?
Continue to come to and drive by my house. She's threatened to come to my work all she wants in the past. It's just a lot of continued harassment and mental and emotional upheaval.
Okay. You say the three things you stated: continue to drive by. I assume that's by your home. Is that correct?
Yes, Your Honor.
Come to your work and to harass you.
Yes.
Is that it?
Yes.
Okay. Let me ask, has those particular three things, has she done that in the past or threatened to do so?
Yes.
And when was that?
March 9th. She came and stalked my home. March 6th, she stalked me in public.
Okay, when you say, for instance, stalk me at home, you're going to have to tell me what she did that you claim to be stalking.
Well, I sent my mother to do the custody exchange with our son. And afterwards, Brittany decided to come drive by and check out my home and what I was doing there. She drove by super slowly, and my mom and Landon witnessed her doing so. Then when I addressed it, she said she can do that all she wants and will continue to.
Okay. How about the incident when you said she stalked you? What did she do?
On March 6th, we had a hearing at the courthouse. I let her leave well ahead of me and stayed at the security podium while she left the courthouse. Then I went out and my girlfriend hopped in my van to talk to me and just unwind after the hearing. That's when Brittany was pulling out. She saw us sitting in my van, and then she returned to the DHS parking lot behind me across the road and stayed there for a good 20 to 30 minutes until we left.
Anything else?
There was custody exchanges where she decided to bring, I guess it's her boyfriend. After trying to communicate an email about her meeting my girlfriend, who was on the verge of meeting our son, she just decided to bring an aggressive male to our exchange. They tried to instigate things as I exchanged Landon, and then she insisted that I bring my girlfriend to the next exchange. At that exchange, she got very aggressive, loud, kept moving towards me. I had to sit down in my vehicle and just be quiet to not violate her PPO, but I felt very unsafe.
So respondent, Ms. Jenkins, she has a PPO against you?
Not anymore.
Okay.
She did at the time.
Okay.
I dropped my PPO during the custody arrangement.
Okay.
He asked me to drop it, so I dropped it just so he could try to get one on me.
Okay. Anything else, sir?
No, Your Honor.
Okay. Ms. Jenkins, let me know what's your response to the allegations made by the petitioner.
I drove by his house that one time to see why he was not there to pick up his son, because I was unaware at first that his mom was there to pick him up. So I wanted to know why he was not there. I have not been by his house since, except for yesterday when I picked up my child because he was in jail for domestic violence. Is the only time I come to his house.
Okay.
And he's saying I harassed him in public. I was on the phone with my lawyer after that custody case, across the street on the phone with my lawyer, talking with her, not watching them. Also, he wants to say I harassed him at his job. One and only time I went into his job, I did not know he worked there till I seen him and I walked right out because he worked there. He profusely sends me emails asking where I live, who's around my son, constantly harassing me over email.
Okay.
And I tell him, you want a PPO, please leave me alone. And he profusely continues to harass me through email, and also changing my son's doctor's appointment so I am not allowed to go because he makes them during his week and when I have to work, after I already set my schedule through work for his heart appointment. And he's done this many, many times before, changing his appointments on me, so I can't go.
Okay.
I have not bothered him since we had this custody agreement started. He emailed me the day he got our son back. The whole week I had him, I did not talk to him at all. And as soon as he gets him, he's emailing me, harassing me. And as for Ryan Brown, he is no longer in the picture, so he is not a worry. And at that exchange, we were both going at each other's partners, not just me. He was going at Ryan and I was going at his girlfriend. We were both in fault for that one. But then we got in my vehicle and we left.
Anything else, ma'am?
Nope.
Okay. Mr. Hathcock, do you have any questions of Ms. Jenkins?
Yeah, she stated that there was.
No, that's not this isn't a time to make a statement. It's a time if you have a question for her.
Oh, I was saying she stated that she only harassed me on my job once, but I'm speaking towards the emails following that, stating where she would come there anytime she wants, all she wants.
Okay, is that a question?
I guess.
This is your time to question. This is your time to question respondent if you have any questions.
I guess not. I don't know how to form it in a question right now.
Okay,
I'm
fine.
trying to.
Okay. Anytime, Mr. Hathcock, this time for any statements that you have then. Go ahead.
The allegations of harassment, I'm not including any emails or communications that do involve our child. Anything outside of the scope of that is what I am considering harassment here. The statements about dropping the PPO to get one on her is not true. The PPO was used as a tool to get me to come to agreements, and then it got dropped. She stated that things were going so well that she wanted to drop it to her lawyer, and her lawyer stated that to my attorney. In that, I didn't agree with it at all. I thought it still needed to be in place. That's part of why I'm doing this.
Okay. Ma'am, any statement you would like to make?
Yes, that is completely untrue. I never wanted to drop the PPO because I fear for being around Craig because he continuously harasses me. I never wanted to drop it. I dropped it so we could agree to get week on, week off with my child instead of every 2 days. So I agreed so that way hopefully things would get civil and, you know, a week apart from each other would do better. But the next thing I know, he's filing for a PPO shortly later because he's in fear of me.
Okay. Well, in this particular matter, the court has heard the testimony. The petitioner has relied upon basically 3 events. The first being March 6, 2023, where he claims that the respondent stalked him when, again, as a result of following a court proceeding, she pulled out of the parking lot, then, in fact, went into a parking lot across from him for about 20 minutes. She has acknowledged that she did, in fact, do that, but that at that time that she pulled into the parking lot, she was talking to her attorney. There was no exchange of anything between the parties in this particular case. The other incident happened on March 9, 2023, where he claims the respondent stalked his home when she drove by slowly. She acknowledges that she did drive by slowly, that this was one occasion in which she did, and that had to do simply a situation where he wasn't appearing at a exchange for the child, and she wanted to know why he was not appearing at the exchange for the child. There was another occasion in which both parties acknowledged that their significant others were involved in a situation, and there were arguments, yelling, screaming, apparently at a child exchange. I would state, as it relates to the child exchange, either party, if there are problems with that exchange, can petition the court, and the court can put some parameters as to where the exchanges occur, the time the exchanges occur, who can be present at the time that the exchanges occur. And that would be the recommendation of this court. If we have difficulties with that, the court can prohibit anyone in particular from being present at those exchanges if that, in fact, continues to happen. In this particular matter, the court can grant a PPO if there's reasonable cause to believe that an individual has committed or may commit any of the acts listed under the statute, being MCL 600.2950, parens 1, parens 1 through K, as set forth by the petitioner and as confirmed in his testimony today. The court finds that those instances, the 2 instances that he relies upon, are not a sufficient basis to satisfy the statute. And as a result, the court is going to deny the personal protective order in this matter. I will let you know, sir, if in fact conduct occurs in the future that would in fact satisfy the statute, you have a right to repetition the court at that particular time. And the court would suggest that you do it if you have a legitimate basis for doing so. But the court does not find that to be present at this time. So I'm going to deny the request. That will conclude this matter at 11:13 a.m. You're free to go. Have a good day.
Attending via telephone. Respondent is not present.
Okay. This matter is before the court on the petitioner's motion to extend the PPO. There was a PPO entered back on July 14, 2023, entered by Judge Yost Johnson, which was effective on that date. Well, effective 7/14/2022 through 7/14/2023, and that the petitioner has filed a request to extend that. Ms. Bertzel, first off, I know we don't have a proof of service showing that you served the motion on the respondent. Did you in fact serve that motion?
I had the sheriff's department serve him. I ended up having a sheriff's deputy call me and ask me if I had his phone number, and I gave her the phone number that I had, and she said that that was the phone number she had, and it looked like they were moving. And she said that she left her card in their door, and she would know if it got removed. And, you know, but other than that, that was all she told me.
So, okay, so it appears, at least based upon that, you've not gotten anything back from the sheriff showing that there was proper service. Is that correct?
Right.
Okay. Well, what's going to happen in this matter is the court can't proceed unless we have a document, a proof of service showing that the respondent was in fact served. And apparently from what you've stated, you don't have that. And as a result, the court cannot proceed until we get that. So you're going to have to acquire service and get a new date to come in for the hearing, because you'll have to put that in the new the notice to the respondent, and then we will be able to hear it at that time once you have service upon the respondent. Okay, you understand that?
So I'm going to have to pay to have him served again?
Well, he hasn't been served yet because you said that the person simply was out to the house, but they did not serve him, and as a result, there is no service at this point.
Well, I haven't got anything from them, but they turn that right into the court. They don't send that to me.
Well,
so I wouldn't know.
Well, the court doesn't have any proof of service showing service. So the fact that there is no proof of service in the file would, in fact, infer that there was no service. So you're going to have to check that out and find out what's happened in this matter as it relates to service. Okay.
Okay. Now, if he has moved and I don't have his address, how would I go about doing that?
Well, you'd have to file, if you don't have an address, you have no way of contacting, you'd have to do a motion for alternate service and get an order which would allow you to serve him by other means, either by publication, by, again, last known address, by tacking it on the door, et cetera. That's all going to be difficult if you have no address, but you can file a motion for alternate service.
Okay. Now, would certified mail be considered alternate service?
Yes, if you had certified, if you had basically a return receipt requested so that he signs for it, then that would be sufficient. So.
Okay.
But what I would do is direct you to Michigan Court Rule 2.106. That's for alternate service, and that'll kind of help you go through as to what you have to do. Okay.
Yes, sir. Thank you.
Okay. Thank you. The court will end this matter 11:19 a.m. You're free to go. Have a
Amber
good day.
Johnson versus Michael Johnson, attorney Thomas Schaefer for plaintiff and attorney Ashley Smith for defendants.
Good afternoon to all of you.
Good afternoon, Judge.
We'll start. We'll start with Mr. Schaefer as he represents the plaintiff. What issues do you believe to be in dispute, Mr. Schaefer?
I believe the children issues are in dispute, Your Honor, along with the property issues.
Okay. Let me go. Hold on. Okay. Ms. Smith, any other issues that you believe are in dispute?
No, Your Honor, I believe those are the main ones.
Okay. Have you engaged in discovery? Do you still need to do discovery, or have you completed discovery?
I think we need discovery yet, Your Honor. I think everybody, the attorneys got in late on this particular matter, so I think we need discovery time.
Would you be able to be complete by August 1?
I think so, Your Honor.
Okay, Ms. Smith?
Yes, Your Honor.
Okay. Put it in as August 1. That way we can get the mediation in August. Mr. Schaefer, who would you like as a mediator in this?
I would recommend Brundage, Your Honor.
Ms. Smith, do you have any problems with Mr. Brundage serving as the mediator?
I do not, Your Honor.
Okay. I'll just tell you, make sure you get to Mr. Brundage right away, because I know he is scheduling in August already, so.
Okay, I'll contact him as plaintiff to get that arranged.
We'll schedule the settlement conference for September 11 at 1:30 p.m. Parties are required to be present unless they come to a full resolution prior to that time. And with that, anything else, Mr. Schaefer?
Nothing further, Your Honor.
Okay, Ms. Smith?
No, Your Honor.
Okay, thank you. We'll do this and get it out to you. You'll get it in a few days, and then we'll hopefully the matter will progress and you'll be able to get resolutely some
Attorney Shelley
items.
Huffman for defendant.
Okay. Good afternoon to both of you. I'll start with you first, Mr. Scott. What issues do you believe to be in dispute in this case?
The custody of the children.
Okay. Ms. Huffman, what issues do you believe to be in dispute?
I would agree custody, child support and parenting time are all in dispute at this time. The parties do have an agreement to the marital assets and debts. However, it's not in writing and it's not on record. So at this time, I would consider it still in dispute until it's
Okay.
in writing.
Is there any spousal support disputes?
No, it would be forever barred.
Okay. Mr. Scott, any spousal support issues?
Not that I know of.
Okay. Are you in need of discovery? Have you completed discovery or are you still, you don't need it?
I would need just a short time, if any, just 3 weeks probably would be enough.
Okay. Mr. Scott, are you in need of any discovery?
I don't believe so.
Okay. Okay, let's put, who would you like, Ms. Huffman, as a mediator?
I would like Mr. Brundage,
Okay,
and in the event he can't do it, then I guess, Lisa, McNiff.
okay. I will tell you, Ms. Huffman, you're going to have to contact Mr. Brundage right away. I do know from other cases that he is scheduling already in August, so I don't know if he has any dates in July left.
Okay, thank you.
What I'll do is I'll set the matter for later August for a settlement conference. That way, if you have to get into them in earlier August, that'll still give you a little more time. I'll set August 21st as the settlement conference date. Parties are required to be present unless they've come to a full resolution prior to that time. With that, I'll ask Mr. Scott, do you have any questions in this matter?
I suppose I don't right now.
Okay, thank you.
Mr. Scott, if you do end up wanting to talk to me or have questions, you're welcome to talk to me as long as you don't have an attorney. So you can contact me anytime.
Okay, thank you both. We'll end this matter at 1:37 p.m. You're free to go. Have a good day.